You think you know Elon Musk, billionaire, tech genius, the man behind rockets, cars, and satellites. But what happened in that quiet courtroom on a rainy Tuesday morning in Portland, Oregon? No one expected. No lawyers. No entourage. Just Elon. Alone. Calm. And what he did left a federal judge, three attorneys, and an entire nation stunned. The secret behind this courtroom battle? You'll find out in a moment. But let's just say it wasn't about money. It was about principle. It started with a $3.2 million fine. Elon Musk had allegedly violated a sealed court order related to a regulatory lawsuit involving one of his lesser-known companies, Voltage Dynamics. At a tech summit in San Diego weeks prior, he casually referenced a dangerous flaw in one of their supply partners. That flaw had been discussed during a sealed hearing. The court interpreted it as a violation of confidentiality. Judge Meredith Hawthorne, known for her no-nonsense demeanor and laser-sharp focus on courtroom protocol, was assigned to the case. Her track record, unforgiving to celebrities and powerful individuals who believed they were above the law. Courtroom 12C was barely half full. Rain tapped against the tall, narrow windows. Reporters expected a brief hearing, maybe even a no-show from Musk. But then the doors opened. He walked in alone. No security, no PR team, a simple gray suit, unbuttoned coat, no laptop, just a single folded paper in his hand. The judge raised her eyes, nodded, and without delay, began reading the charges. Elon Musk, you are found in breach of federal court confidentiality protections. The court levies a fine of $3.2 million to be paid in 14 business days. No audible reaction from Musk. No sigh. No raised eyebrow. Just a soft reply. I understand, Your Honor, but I would like to respond, if permitted. Gas rippled through the gallery. Judge Hawthorne paused. You waived legal representation? I did, Elon nodded. Respectfully, I'd like to speak for myself. She gave a cautious nod. Proceed. That's when things began to shift. Musk stepped to the podium, unfolded the sheet of paper, and began. I'm not denying I spoke. I'm not contesting the timing. What I am contesting is whether what I said was actually protected by the order you cited. He referenced Section 9B.3 of the protective order, which included an exception clause allowing public disclosure for urgent matters of consumer safety. I disclosed a safety flaw that, if uncorrected, could have caused harm. The language of the order makes an exception for disclosures that are in good faith and in the public interest. The judge raised her eyebrows. And you're suggesting you qualify under whistleblower protections? No, Your Honor, Musk replied calmly. I'm suggesting that punishing disclosures made in good faith for public safety undercuts the very law meant to protect consumers. Murmurs filled the room. Legal teams behind the prosecution exchanged glances. One attorney quickly began typing notes. Musk continued. I've reviewed case precedent, Ashcroft v. Leontech, Ninth Circuit, 2009. In that case, the judge ruled that sealed orders cannot override legal obligations to alert stakeholders of imminent safety risks. That ruling applies here. He passed up a copy of the transcript. Judge Hawthorne read in silence. The courtroom hushed. You're suggesting, she finally said, that the fine this court issued exceeds its legal boundaries? I'm suggesting, Musk said without hesitation, that if courts ignore exception clauses when levying penalties, we risk undermining the integrity of both law and public trust. There was no arrogance in his voice, no legal jargon to impress, just quiet, confident logic. This wasn't rebellion, he added. It was responsibility. After a 90-minute recess, the courtroom reconvened. Judge Hawthorne entered with a different demeanor. I reviewed your documentation, Mr. Musk. I also revisited the language of the order and the Ashcroft ruling. You are correct that the exception clause applies if public safety is at risk, even if the disclosure wasn't authorized. Shock moved through the room. But this court does not excuse misconduct lightly. While I'm not voiding the penalty, I am reducing it to a symbolic $20,000, a recognition of both technical violation and honorable intent. Elon nodded. Thank you, Your Honor. As Elon left the courtroom, Reporters swarmed, expecting defiance or triumph. He gave neither. Just one line. "I didn't come here to win. I came to be understood." The media called it the silent defense. Legal experts began referring to it as the Portland Principle. When a defendant uses legal precision, not privilege, to challenge authority. Law students downloaded the court transcripts. One retired judge said on national television, "Elon didn't beat the system. He reminded the system what it's supposed to be." In an era of noise, Elon Musk didn't shout. He didn't posture. He didn't even bring a lawyer. He read the rules. He respected the court. And he showed that sometimes logic and clarity are more powerful than wealth and influence. Not everyone agreed with his approach, but no one could deny what they saw. So here's the question. What happens when more people start reading the fine print and speak with precision instead of fear? Maybe that's when real change begins.